Hi, my name is Shraddha Bista. I'm a registered migration agent, and today I'm going to talk about the 12-month rule when it comes to partner visa application as a de facto partner applicant, and how to get rid of the 12-month rule by registering your relationship as a civil partnership. And I'll also talk about two common misconceptions when it comes to registering your relationship. First of all, if you are not married and want to apply for a partner visa, you have an option to apply as a de facto partner if you have been living with your partner for 12 months. Now, living with your partner for 12 months does not mean you have to be living with him continuously for the whole 12 months. If you are separated by circumstances beyond your control, and if the separation is a temporary separation and not separated permanently. Example, you are currently on a skilled regional visa and your partner is living in Sydney, then you can't, and your partner cannot leave his or her work to be with you, then that's circumstantial separation. Then you can still qualify to say that you are in a de facto relationship as long as the separation is a temporary and not a permanent separation. Most importantly, if you haven't reached the 12-month de facto mark, then what I suggest as an alternative option to all my clients is to register the relationship as civil partnership at your state and territory. Now, do note that all the other states and territory recognizes the civil partnership except Western Australia and Northern Territory. The general rule to registration is that both the couples have to be above 18. Neither of the couple can be in a married or de facto relationship. So if they're previously married, they need to show proof or evidence of divorce, and both the applicants cannot be related by family. There are some residence requirement depending on which state and territory you're from, so please be familiar with your state and territory requirement before you apply for the registration. So the two misconceptions regarding registering your relationship is that, first of all, a lot of the times people think that you need to register your relationship at time of application. So before you apply for the visa, people would rush to register your relationship, which is not necessary and which is not true. You can first of all apply for your partner visa application as a de facto partner. If you cannot meet the 12-month mark as a de facto partner, you can apply for the registration after you have applied for the visa application. So how it works is you apply for the visa application even though you haven't reached the 12-month mark, and then you'll be granted bridging visa, most likely bridging visa A, and you will have almost 2 years when you wait for your first stage grant for your partner visa application. But I would suggest you to register after the visa application. You wouldn't wait for the whole 2 years. So you would apply, get bridging visa A, and then register your relationship. That way you will still waive the 12-month mark requirement and you will still qualify as a de facto partner. However, if you've applied as a de facto partner and you want to get married after your visa application and before the grant of your first stage of visa application, you might have a problem if you haven't completed the 12-month mark and if you haven't registered prior to the application. If you do get married, your application as a de facto partner will be void. So I hope you are in no rush to get married. Other than that, there's no problem for you to apply for your registration of your partnership as a civil partnership after the application. Which brings us to the second misconception, and that is the couple needs to live together or be in a de facto relationship prior to applying for the registration of civil partnership, which is again not true. You don't need to be living together to apply for your relationship registration. For example, the partner can be living overseas, or in some cultures, people are not allowed to live together before marriage. So you can still register your relationship as a civil partnership even though you are not living together, even though you are living in a separate countries, you can still register and apply for the de facto partner visa. So hopefully this has cleared your misconception if you had any regarding de facto partner visa application, the 12-month mark criteria, or regarding registering your relationship, whether you had to register prior or whether you can register after you lodge the visa application to qualify as a de facto partner. Please note this video is a general information only. It's not a migration advice specific to your circumstance. And if you do require any immigration or migration advice, please feel free to give us a call or send us an email. I hope this video was helpful, and I'll see you next week.